This is the Millennials in Multifamily podcast, brought to you by Kronos Investment Partners. We interview industry experts to unlock key information that will help young professionals break into the multifamily world in order to create long-term and short-term wealth. If you enjoyed the show, please head over to iTunes and leave a rating and written review so we can reach more listeners.
Thank you for joining us on today's episode of the Millennials in Multifamily podcast. I'm your host, John Stober, with my co-host, Ryan McShay, and today our guest is Gene Trowbridge. Gene is the founder of Trowbridge Law Group, where his law practice concentrates on the syndication of commercial and investment real estate through both debt and equity. As a former syndicator who for 10 years raised investor capital through the broker-dealer community, Gene is able to communicate with his clients on both the technical and the practical aspects of state and federal securities laws. Gene Trowbridge, thank you so much for joining us on today's episode of the Millennials in Multifamily podcast. Now, you have a very unique background given that you are both a real estate syndicator and an established attorney. So could you give our listeners just a little bit more about your background and yourself and how you got started in this business?
Sure, John, that would be great. Thank you. Thanks for having me, first of all. When I came out of college, which was a while ago, I went into the commercial real estate business, and I was listing and selling and leasing properties. And somewhere along the line, I went to a conference, and the conference had a session called A Retirement Plan for Real Estate Agents. And I went to that session, and it turned out to be really for residential agents. But their message was to a residential agent, buy one half of a house each year, get an investor to buy half, you buy one half, and do that once a year for 20 years, never sell anything. And that was actually my first exposure to the fact that you could actually buy some real estate by teaming up with someone else's money. Now, that sounded like a good idea, and I wish I had done that. I'd be better off today than I was. I didn't do that, but that got me interested in how you pool investments. So within a year, I went out and got three guys I'd gone to college with, and we bought an apartment building. We were living in St. Paul at the time, and bought an apartment building, and that was fine. That was good. So I bought another one with another group of investors, and then moved to California and decided I wouldn't be a commercial broker. I'd just be a syndicator. So that started about an 18-year career as syndicating. And I did a number of different types of property. My first one was a mobile home park, and I didn't care much for the management of that. My next one was a couple small apartment buildings, and I didn't care much for the management of that real estate. And somewhere along the line, it's too long a story, but I ended up building storage facilities. And our task was to go out and buy the dirt, get the storage facility built, and when it got to about 50% absorption or occupancy, we sold it to one of the many operators that operate storage. And half of our units we sold to public storage. So that was a good business, and that lasted quite a while. And then I remember, I say this in my own presentations, one year I sat back and looked, and I had sent out 1,767 K1s. And I said, this is insanity. You know, I don't want to do this anymore. So I came home to my wife, and we sat around the kitchen table where all the great decisions are made. And I said, you know, I think I'm going to quit this. I've got 6 or 7 years of income flowing in from this, and I think I'll go to law school. And I'll go to law school to be one thing, a securities attorney. And I was 45 then. And I've been doing this for 27 years, so I'm not going to tell you how old I am, but I'm drawing my Social Security, and that's fine. So what do I bring with me? I bring with me the fact I was a syndicator and saw the good things and all the bad things about that and know all about that. And so now I bring that to my clients.
That's gotta be
So
a confidence.
I was a young guy when I started, just like most of your listeners.
Yeah.
And that's exciting, very exciting.
I do have a question. You get into the syndicating world at a younger age. Back in the day, a lot of people today have the books, the internet, so many resources to get introduced into syndicating. But back then, it feels like it was probably more of an exclusive club of people that knew how to operate that way. I mean, how did you get introduced into syndicating, and who were some people that led you along the way of that?
I gathered three of my friends out of college. The four of us collectively put $40,000 down collectively on a $120,000 12-unit apartment building in St. Paul. And one of the guys was an attorney. And he showed me what the documentation was. And he used the word syndication. And all I had to do is study from there on. I had just had to study. But, the issue back then was you couldn't advertise for investors at all. The only way you could take investors in would be, people call it friends and family, but let's just call it people that you know. And so that was a little different game than it is today. But in some ways, that was better in my way of thinking. And we'll probably talk about how that is working today. But I would say the first 4 or 5 of my syndications were strictly with people I knew. And then, as luck has it, I sat alongside of a president of a small regional broker-dealer firm here in Orange County, California, where I live now. And I gave a speech. And I came back to sit down and finish my lunch. And he says, geez, that's interesting. I love what you have to say. If you have a project, bring it to us. Maybe we can raise some money for you. And the rest is history. So I really stopped raising money myself. I was wholesaling, which means I went to the brokerage company offices and told my story to the stockbrokers, the registered reps. They had the Rolodexes of all the clients. And that was a pretty heady business. I could raise $5-7 million in a week, bringing my offering out. So that was good. That was a good lunch I went to, right? The food was bad, but the guy I sat alongside him was great.
So, Gene, that's a really interesting point, though. You mentioned broker dealers and using them to raise money for you. Mm-hmm. You've been in this business a pretty long time. And I'm wondering, from your perspective, how come more investors aren't utilizing broker dealers to raise money for their deals?
The cost of entry. The cost of entry. A broker dealer isn't going to raise money for you if you can't bring $25 to $50 million of product to them every year. Mm-hmm. Because doing the due diligence on you and the risk they take on doing your little offerings isn't worth it. And why is that? Because today they can sell shares in REITs. REITs publicly traded, full liquidity. They can just sell people their REITs as opposed to a storage facility in Barstow, California. In the old days, that wasn't the game. The game was selling huge limited partnerships that bought real estate all around the country. And my niche, and everyone has to have a niche, guys, my niche was bringing local real estate to high-income investors who wanted to invest locally and drive by the property and show their friends that they owned a piece of that property. That was the game back then, and I was at the right place at the right time.
So were REITs not really prevalent back then?
No, they weren't. That's a relatively new form of investment. And it solves a lot of purpose. A REIT is public. They can advertise. They can sell in small dollar units. And some REIT shares are publicly traded, or at least there's liquidity. And so that's pretty good. That's the type of product that a broker dealer would like to sell. Now, I do have some of my clients who can go into the broker dealer network and get their deals approved. And it's still pretty much local real estate offered to local broker dealers and their local clients, but you have to have a track record and you have to bring them enough business to have it worth their while. But we're going to talk about crowdfunding platforms a little bit later, and that's really an alternative to the broker dealer network, which might be a little more easy to get involved with. So we'll talk about that later.
Do you mind talking about it right now? Could you tell us?
No, I've got time.
Yeah. So what is crowdfunding and what are the differences between that and utilizing a broker dealer?
Well, crowdfunding has really turned out to be just a word. In the Jobs Act in 2012, they passed something called regulation crowdfunding, which at that time let you raise $1 million in 1 year from non-accredited investors, and you could advertise, and you had to use a broker dealer to go through that. Well, that has not proven to be popular, but the word crowdfunding is popular. You know, you hear about it all the time. Go fund me. Gene Trowbridge wants to take a vacation to China, which maybe isn't a good idea right now, but he wants to take a vacation to China, and he says, send me some money and I'll take my family to China. Or I need braces. Or I need a big wedding. So that's a donative. That's a gift. But that's all crowdfunding. They go to the crowd and raise money. Well, we do the same thing in syndication, except in the syndication, it's a business and there's a profit motive. That takes you into the securities world. And once the Congress decided they would let crowdfunding go into the securities world, they created this regulation crowdfunding. We don't do any of those offerings. No one I know does any of those offerings. Been very few of them that have been successful. But we use the word crowdfunding. The last partnership I was in, we used the word crowdfunding lawyers. It's just a word. But we're doing syndication. We're pooling money from multiple people to make real estate investments with an expectation of profit.
So is that any different from Regulation A or a Reg A offering?
No, if you want to use the crowdfunding word, it's anytime you go out and raise money from a bunch of people. Regulation A is a rule that the SEC has administers that tells you how you can publicly advertise to people who are not accredited. It's the only game in town, unless you go to a public offering. It's the only game in town that'll let you do sort of a private placement, advertise, and take non-accredited investors. It's expensive to get approved. You need a permit from the SEC to sell your product. You need to do audits. So it's quite cumbersome, but there are some people that use it. You guys know Grant Cardone?
Yeah.
Okay, Grant raises money in his Regulation A+, and in the former law firm I was with, my partner Jillian did Grant's legal work on, and that was pretty exciting, pretty heady time, but that isn't for everyone. You know, just because you can advertise doesn't mean anyone's going to send you any money.
Right.
You need a track record, you know.
So what would you say are the best platforms for crowdfunding, and what's the standard for who
and why are they good? Why is crowdfunding good? Well, I look at a crowdfunding platform as like an MLS of properties. If you can, as a syndicator, can take your money, take your product to the crowdfunding platform, and they put it on their platform, then all these accredited investors can look at it and decide if they want to invest in it. It's only for the offerings that allow you advertising. The only investors you can take are accredited investors, And the crowdfunding platforms really are in the business to build a database of accredited investors. And some of the bigger ones might have 20, 30,000 accredited investors on their platform. So then if you can put your property right up there, and they come home at night and they go on the web and they look at your property, and it's somewhat vetted by the time it gets there by the crowdfunding platform. Maybe they'll send you $50,000 and invest. That's a much easier entry than the broker-dealer community today. You still need a track record. Maybe you need to have done $25 million in offerings, but they really don't have a requirement of you bringing $50 million a year to them. They don't have anything like that. You bring them a deal. If it's a good deal, they'll put it on their platform. Everyone sees it, and they're quite successful. CrowdStreet and Real Crowd are the two that I seem to have some luck getting people into. And those platforms really help you raise money. There are other platforms out there that don't help you raise money, but they help you with the back office management. When I said in my introduction that I sent out 1,676 K1s, you can imagine that was a task. Well, today, and this wasn't there back then, but today I could sign up with Redwood Real Estate Management, or I could sign up with Investor Management Services, and my investors go right through their portal into their record-keeping system, and they don't help me raise money, but they take care of everything, the K1s, the letters to the investors. It's pretty nice. It's great back office support.
Those back offices are very sophisticated. I've seen how they track all of the documents like a checklist that you need.
Right.
It's very nice. If you budget for it, it can be a very great tool.
It's really good. It's the only way you can handle a multitude of investors and all the documents there are today. I mean, you can staff up, but all that staff will eat into your profits.
Mm-hmm. So, Gene, as the attorney, what role do you play in getting these properties listed on the crowdfunding platforms?
One of two roles. The crowdfunding platforms either will send someone to me who needs an attorney. Mm-hmm. Someone will call CrowdStreet and say, "Hey, I've got this offering," and they'll say, "Do you have your documents?" "No." "Can you refer me to an attorney?" So they'll refer that person to 2 or 3 different attorneys. And then the other side of the coin is my more experienced syndicators who've done a number of deals and have the track record that I think is necessary. I can introduce them to the crowdfunding platform, and then they know that the documents are right. And so it's a two-way street. I get referrals and I refer people to them.
So you're drafting up the PPM, private placement memorandum, and then how are you distributing that to the platform?
We distribute it to the platform in a Word document. Mm-hmm. Okay, and then the platform puts it on however they do and distributes it to the investors. I really don't have much to do with it after I have the final document. Mm-hmm. and I send it to them. That's the distribution pattern. If I were not using a crowdfunding platform, and let's say you two guys are doing the syndication, I provide you with the final document, probably in a protected PDF, mm-hmm. and you decide how you're going to distribute it.
Can you discuss the different rules for advertising between a 506C, a 506B, and a joint venture, and how you would go out and promote those?
Sure. That's not the first time I've been asked this question. Okay. We have to go back a step and talk about what is a security. Okay. And a security simply is an investment of money by more than one person into a common enterprise, meaning everyone is doing the same thing. And we generally say into an LLC or a limited partnership or a REIT or a corporation. So an investment of money by more than one person into a common enterprise where the investors are expecting a profit. But it's going to happen through the efforts of the promoter. That's really what makes it a security, that the passive investors give their money over to a manager, the fund manager, the managing member, the general partner, whatever it is, turn their money over to that group, and then that group manages the money inside of the common enterprise. Now, when people are managing money of other people, Congress has always had an interest in regulating what are they selling and who's selling it. So the securities laws that came out in the early 1900s, 1930s actually, there's one law that regulates what it is you sell, and then there's another law that regulates who is selling it. So we have to know what a security is. Now, the securities rules only have to do with how do you approach investors. It doesn't have to do with whether it's an LLC or a limited partnership or a REIT. That isn't it. The securities laws is how does the sponsor, how does the syndicator go out and raise money from people? Let's start with your question with a joint venture. The question is, in a joint venture, how do they take title? What's the entity? Generally, a joint venture is like a general partnership. Mm-hmm. Two people coming together with money and expertise. They come together and they make all the decisions together. Okay? That generally doesn't raise to the level of a security because it is an investment of money in a common enterprise with an expectation of profit, but no one person is in charge. If the fourth element, solely through the efforts of the promoter, isn't there, it's not a security, so you can do whatever you want. You can raise money any way you want. In the limited liability company, the LLC world, we could call that a member-managed LLC. 3 or 4 people get together and buy a building, and they make a document, they make an operating agreement that says all the major decisions will have to be unanimous. Not by percentages, because they can invest different amounts of money, but if there's 4 people have to vote yes for the major decisions. And so in that case, there's no solely through the efforts of a promoter, so it's not a security. So you can raise money any way you want. Your question really goes to, what are the rules of advertising when it's a security? Okay, that's really the issue. And we already talked about Regulation A and A+. That's an offering, that's a security, and it has rules about what you can do. And you can advertise, but the SEC approves every word that you say in your advertisement. Now we get down to private placements, which is what all of your listeners want to do. They want to go out and raise money from family and friends and people that they know and not get involved in the SEC and all the regulations and audits and everything. So they want to do what's called a private placement. And the biggest market for private placements is Regulation D. When the securities world came about and the regulations were written in the 1930s, the SEC said, there's a whole bunch of people out there who don't need our protection. And they called those people rich and smart. Then they gave a better name to it, and they called them accredited. And so they basically carved out a whole section out of their regulation and their supervision for people who only raise money from accredited investors. And there was no advertising allowed. There was nothing. You just raised money from accredited investors that you knew. In 1981, they came along and said, well, there are a lot of people who would like to invest in these private placements. Private placements really are the financial engine for small businesses. So let's open it up to people who aren't accredited. And so they created Rule 506, Regulation D, Rule 506. You can take all the accredited investors you want, you can raise all the money you want, you can't advertise, and you can take 35 sophisticated investors. People who don't meet the definition of accredited but are smart and have experience or advisors to help them determine if they should invest in that. So that was what it was from 81 to 2012. And here comes the Jobs Act. And I'm going to use myself as an example. When I was raising money under Reg D, Rule 506, I couldn't advertise. I knew a number of accredited investors, and the broker-dealer community, those people knew accredited investors, but we didn't know all the accredited investors. So I could only raise money from a certain group of people, and then a certain group of accredited investors knew me, but they didn't know all the other people who had good projects on the street. So the Jobs Act said, we need to promote capital formation. Private placements, Reg D, is only about a $1.8 trillion annual marketplace. There's more money raised in Regulation D than there is on the New York Stock Exchange in a year. Government said, Congress said, let's open it up. Let's let Gene Trowbridge advertise and find all the accredited investors that are out there who might want to invest with him. And let's let all the accredited investors find all the people like Gene Trowbridge so they can see what offerings are out there. And as we expand and explode that market, we'll raise more money for small businesses. So they took Rule 506 and they divided it. B is the old rule. No advertising, 35 sophisticated investors, and an unlimited number of accredited. 506C is the new thing that they carved out. Unlimited accredited, raise as much money as you want, advertise the hell out of it, but you have to make sure, you have to take steps to be certain that the people who do eventually invest with you are accredited, which is just some sort of a reference check. So joint venture probably is not a security. It would be a security if I said to you, you guys put up the money, I've got the bulldozers, we'll build a building, but I'm making all the decisions. Mm-hmm. That's a joint venture. That's a security. You got the money, I've got the bulldozers, we'll make all the decisions jointly and unanimously, not a security. A lot of gurus are out there on the speaking trail, and they talk a lot about joint ventures. Their message is, if you do a joint venture, you don't have to worry about the securities rules. That is only true if no one's in charge. The minute someone's in charge, or you vote based on a percentage, I have 80% ownership and you have 20, I'm going to make the decisions, right? That's a security. So you need to be careful when you listen to people when they say that. Another problem with joint ventures, how are you going to do unanimous decisions with 15 investors? Mm-hmm. You're not. Okay. How are you going to do a member-managed LLC with unanimous decisions with 6 investors? You're not. So you're going to have solely through the efforts of the promoter in the most instances, and that's going to create a security, and you just have to follow the rules. It's not a real headache. Regulation D has 5 or 6 little rules. You got to have a PPM. You can or can't advertise. You have to have a bad actor questionnaire. Relatively simple rules. You have to follow them. I sound like a preacher here. The securities laws, that's a criminal statute. So if you don't follow the rules, you're going to be in trouble. Okay.
Are you struggling to understand how to underwrite multifamily properties? Hi, I'm John Stober, and I completely understand your problem. I thought underwriting would come naturally to me due to my background in finance and accounting, but I quickly found out that there aren't a lot of resources that cover this subject. I had no idea whether what I was doing was right, wrong, or just original. I don't want you to have to pick up little nuggets here and there like I did, so I wrote an ebook called How to Analyze Big Apartment Buildings and Make Them Feel Small that puts together all the pieces of the puzzle. We're also giving away a deal analyzer with the ebook, and they're both completely free. Don't wait as long as I did to start chasing financial freedom. Go to bit.ly/underwriting ebook and get your free copy today. So, Gene, how does the SEC determine whether someone has taken an active or a passive role in one of these private offerings?
They look at the operating agreement. The operating agreement will say Trowbridge Equity Group is the manager. And then it'll say, what are the voting rights?
Mm-hmm.
In a deal that's not a security, there's no manager. And they said and it'll say that the decisions are made unanimously by the members. And then it'll list the members.
I have a question. I'm doing a joint venture right now, and we're going over the voting rights in our operating agreement. And a lot of the decisions we are putting, they have to be unanimous. Now, there's one particular item that says, okay, this person is solely in charge, and they are able to sign on documents to make the company legally binding into a contract. Is that something
mechanically that's a good provision, isn't it? You can't have, how many people are in your joint venture?
About 6.
So mechanically, you can't have all 6 run down to the bank and sign all the documents. So you have to do something like that. But those decisions that person is signing on can only be made, or those actions that person can take can only be made after you get unanimous approval from the joint venture partners. What type of entity are you using?
An LLC.
A member managed LLC?
No.
A manager managed LLC?
Actually, no, it is a member managed LLC.
Okay, good. You answered that. You failed the test in the first one, but you passed. That's what erasers are for.
Right.
Okay. It has to be if it's manager managed by definition, if it's a security. If it's a limited partnership, by definition, it's a security because there's a general partner.
That's right.
Okay. So you can do an LLC, you can do a member. What you're doing is a member managed LLC. Mm-hmm. That's the entity that takes title. And whether you call it a joint venture or not, that's kind of up to you. But we've gone past the joint venture thing. You're doing a member managed LLC, which is fine. Just be careful. I've seen member managed LLCs where the responsibility for this day-to-day rotates every 6 months. Someone else does it. That's fine.
So, Gene, out of all your clients that do advertise to raise money, what have you noticed separates the ones that, successfully raise a lot of money from those who fail to raise enough?
In advertising, mm-hmm. As it relates to advertising, mm-hmm. A track record. If you came to me and said, I want to do a 506C, and it was the first offering you've ever done, my best legal advice is don't do that. Mm-hmm. No one is going to send you money. They don't know you, and you don't have a track record. So you've got to have a track record to go to raise money. Now there is a strategy. If you were going to do a small deal, and I'll give you some information in a minute that backs this up. But if you were going to do a small deal, and you pretty much knew who the investors were going to be. Remember, everyone has to be accredited if you're going to advertise. Okay, so that's a limiting factor, but let's assume that's it. And you knew who the investors were going to be. I might do a 506 just for the benefits of advertising. Because the reason you're advertising is you don't have a big database. Mm-hmm. So in 506, you can advertise anyone. There's no rule against who you advertise to. The rule is who invests, and you just have to take steps to be reasonably certain that the people who invest are accredited. So that's a strategy. You do your 506C, and you go out, and for 90 days, you advertise the hell out of it, and you get 200 people in your database. 6 months later, you do a 506B. you've had to develop a relationship with those people, and that's another step. But that is a strategy. Here are the facts. The facts are that of the $1.7 or $8 trillion raised in Regulation D offerings, 1.4 trillion, this is not all real estate, but 1.4 trillion during that period of time was in 506B. Out of 1.7, 1.8, 1.4 is in 506B. 300, 400 million, or billion, excuse me, raised in 506C, which is minuscule.
Right.
And the average offering size of a closed 506C is only about $1 million. So what's happening? Number one, some people are doing small deals using 506C as a strategy for building their database. And another group of people are going out with 506C and they're not successful in raising money.
So what would you say is the threshold for a track record? When you approach, either these different platforms for advertising, or you come to someone like yourself and we want to do a 506C, what would you say is a good benchmark?
Well, I think for the crowdfunding platforms, you're going to have about $30 million of real estate under management.
Mm-hmm.
That's pretty much entry.
Does that need to be current? You currently own that much, or you have done that over your course?
Well, I'd put it both in my track record. Okay. But if you come to them and say, I used to own all this, I don't own anything now, that might not be as good as owning something now, but you put your whole track record together. Coming to me and asking me in what I do something called the deal structure interview. And during that time, we talk about how you're going to raise money, what plan you're going to take. If you have no track record, I will certainly try to talk you out of doing your first deal in a 506C. If you've done at least one deal and you want to come and talk to me about a 506C and it's not a terribly big deal, I think we can probably work that out. With one of the things about 506C is, yes, you can advertise, but if you don't have a database of people to mass solicit and advertise to, how are you going to do that? You put up a web page, and hopefully you advertise to get to people to the web page, and then they look at that and they send you a check for $50,000 with no track record. I don't think so. I know that in the Reg A space, in the firm that did it when I was with Jillian, she had a few Reg A people who had no database, and they just thought advertising would solve it. It doesn't solve it. Doesn't solve it at all.
So, Gene, if you do a 506C or a Reg A to build your database, though, are you even allowed to go back and do a 506B since you've previously advertised?
6 months. There's a rule called integration, and what that rule says, if you do certain things too close together, they're going to all lump it into one offering.
Mm-hmm.
So you need 6 months from the day you close your 506C until you raise money, raise your first dollar on your 506B. And now you can go from a 506B offering. If you start, you could convert that to a 506C. You just have to give everyone's money back who isn't accredited.
Mm-hmm. But
you can't go from a C to a B.
So you mentioned with 506B, you need to have a pre-existing relationship with your investors. How does the SEC define that?
You will get different answers from different attorneys on that. I have some background in how the broker-dealer community dealt with that when I was taking my offerings to the broker-dealer. And the question really was, when does an offering start? Because you have to have a relationship that pre-exists the offering, okay? And my feeling is that when you have a letter of intent, you don't have an offering because you don't even know if you're going to go to the purchase and sale agreement, right?
Mm-hmm.
You have a purchase and sale agreement. I don't know if you're going to close that thing yourself or if you're going to wholesale it or if through due diligence, you're not going to close it at all. I don't know. But you hire an attorney and sign a fee agreement that directs the attorney to draft private placement memorandums and all that. You've stepped over the line into contemplating an offering.
Mm-hmm.
And the word really, the start of all this is contemplating. Your pre-existing relationship has to be before you contemplate your offering. And in the broker-dealer network, the contemplation of an offering is when they take your project and they start doing the due diligence on it. Because if the due diligence is right, they will go ahead and turn it over to their reps and sell it. So just the action of taking some money up front and signing a due diligence a review contract with me says they're contemplating doing an offering. But I think that's a very long answer. My answer is when you sign the fee agreement with me, your database freezes for this offering. You can still put people in your database. They just can't buy this offering.
And so do you only need a pre-existing relationship with the non-accredited investors?
No,
or is it all investors?
No, everyone. And the whole deal about pre-existing relationship is a defense against you being charged that you're advertising. They're going to come if things go wrong and they come to you and said you advertised. Mm-hmm. Your defense is no. I had a pre-existing relationship with that investor who's complaining. I had a questionnaire. I had records in my contact database on the times I met and talked to them. And I have some information through the offering questionnaire that tells me, what their investment experience is. I knew this person pretty well.
Mm-hmm.
Okay, so it's just a defense. To have a substantive and pre-existing relationship is a defense against advertising.
And that actually leads perfectly into my next question. What's the best way for one to prove that they did have a pre-existing relationship with their investors?
Well, the SEC says that a questionnaire is a start. A questionnaire is a good start to proving that. You get a questionnaire signed by the investor and dated, or your questionnaire is on your website, and when they fill it out, you have an electronic record of when they submitted it to you. That establishes a date.
Mm-hmm.
Probably the more complicated issue is it substantial? And there's no rule on that. Plain English is, did you know enough about the investor to know that they would understand the offering, that they were suitable for the offering, that they understood the risks, and that they had a chance to learn enough about you so that you knew when you had an offering, they'd like to hear about it. And it's fact specific, that could take you anywhere.
Mm-hmm.
Well, that kind of leads me into my next question. We've talked a lot about really good questions that the sponsor should ask their attorneys before they, get into this line of business. What about the questions that investors should be asking their sponsors?
Great. I'm glad we're going there. And if you're going to be a sponsor, don't turn this off, because I'm going to talk about good questions that investors are going to ask you. I'm going to frame it from the investor standpoint, but boy, you better have an answer, because all four of these, there are four questions, and you'll be surprised what they don't cover. 4 questions are knockouts if you don't have the right answer. Number 1 question. Ryan, I love your deal. You had a $50,000 minimum. I've got my money. I'm all ready to invest, but I just want to know, once you have my money, what happens if something happens to you? You better have an answer. And the issue there is continuity. What have you done? Is there more than one member in your Manager LLC, is there more than one member in your general partnership? If you don't have continuity, I would advise every investor not to invest. I don't review offerings for other people, for passive investors. But if passive investors call me and ask me, I tell them I don't, but I always tell them one question: read the document, find out who the manager is, and if there isn't continuity, don't invest there. I've been a replacement manager, a general partner 6 times in my career for people who other attorneys let them do offerings where they were the individual manager. Death, divorce, bankruptcy. A guy hit his head on a rock skiing in Park City and became a quadriplegic. Spent a year upside down in traction in a Utah hospital. Just last year, we had a guy come to us and he was going to we raised about $7 million for a mobile home park in Louisiana and wanted to be the manager himself. I talked him into taking someone in his office to be a minority member of the manager entity, a 90-10 split. They raised all the money, and in November, about 4 months into it, the fella developed pneumonia and was dead by Christmas. What would you do? And I thought, thank God he listened to my advice. I mean, you just never know. So that's a knockout question. So you sponsors, you got to have continuity. You've got to figure out how things, and there are a million ways to do it. When I was a syndicator, I had an S corporation as a sponsor with shareholders and a board of directors. Corporations don't go away when a shareholder dies. An LLC with one member is dissolved by an act of law if that member dies. That can be great trouble for your investors. So I'm belaboring that, but boy, that's the number one question.
That's great advice.
Number 2, hey, Ryan, have you done this before? John, have you done this before? Mm-hmm. Every one of us has had to answer that question, no, right? Every one of us. So you got to have another answer. And for the investors, just because they say no, that doesn't mean you don't invest with them. It certainly is something to take into consideration. But I'd like to know, and if I'm an investor, okay, so this is your first syndication. Do you own any real estate yourself? Are you in the real estate business? What's your training? What's your expertise? What's your team? Mm-hmm. You know, we've got a team that we put together 3 or 4 people to be in the manager, and collectively we have all this experience, but this is our first venture into raising money from multiple investors to buy a property. Well, we'll have to, somewhat of a marketing issue. Is your answer going to be good enough for me so I will invest with you? And investors, many times you're going to invest because of the person who's doing the deal, not so much the deal. And if you're comfortable with the person, invest with them. That's fine. And syndicators, protect your investor. Protect your investor. Be ready for that marketing question. Third question. John, I know you and Ryan have this deal. Is this deal good enough that you're actually going to put some of your own money in? Skin in the game. Okay. Now, that's not a knockout if Ryan and John say no. Okay. For some investors, it is. Some investors absolutely will say, I would never invest if the sponsor isn't putting any of their own money in there. But that's not a knockout for everyone. There might be a reason. What's the reason? Your guys are going to sign personally on a $3 million loan. That's enough. Okay? Tell the people that. Sure, you're not putting cash in there, but you're putting your whole life on the line. So be careful about that. And in a situation we had recently, the minimum investment was $100,000, and my sponsor was going to sign on the note and invest $25,000. You don't have to invest what the minimum is. You just have to do something so that your investors feel comfortable investing with you. And then the last question is really from the investor's standpoint. Ryan and John, you know, if I invest with you and something happens to my family and we need the money, is there liquidity? Is there a way out? Good question, right? answer that a good sponsor gives, a good syndicator gives, we've hired professional attorneys to draft our operating agreement. And Article 11 has the complete liquidity provisions. Make sure you read that and ask me any questions and see if that satisfies you as to our plan on what would happen if you need your money out. Now, the whole fallacy in there is that I expect the syndicator to read their documents, which is one of the big mistakes that I see syndicators make in the heat of raising money. They don't always read everything we write for them. Oh, well.
Well, Gene, we're running up on time, so
Good.
I wanted to get to our section of the show that we call the Fast Five, which are the same 5 questions we ask every guest who comes on the show. So if you're ready, we'll jump right into it.
Okay.
Question number 1. If you had to start all over again and you were in your early 20s, how would you do that?
Well, I started in my 20s. I started in my early 20s. I had a real estate background. And I feel very comfortable with that. And I think that's important. The more properties you show, the more properties you sell, the more properties you lease, the more you learn about the property. And then take people with you. See, I don't think you sell a syndication. I think you offer people an opportunity to invest in an opportunity that you have found. So I would have started, the same way I did, talking to my friends. Do you have any money? You got a house, you've got some life insurance. Now what are you going to do with the rest of your money? Let's invest. They don't have time. They don't have expertise. They want someone to manage their money. And that's what I'd do. I'd get on it right away. The problem is, depending upon where you are in the country, it may take a large minimum investment to get an investor in with you. So not everyone in their 20s has 50 grand, okay? So you might have to start small. Figure out what your clientele is, what they're looking for in economic benefits. Find a property type that fits their needs and go out and syndicate it. Don't be afraid to ask.
Question number 2. How do you see young professionals adding value to more experienced people such as yourself, both either in the real estate business or just in any line of work?
I have always surrounded myself with younger people. The last law firm I was in, for a while, we had 2 partners, and then we had 3 partners, and we had 2, and they were all 30 years younger than me. They brought vibrance. I brought mentoring. I brought experience. Right now with Trowbridge Law Group, Jonathan is 34. My partner is 34. I'm 72. I brought experience. I want to train. But there's a lot of things that you guys know, you millennials know. My social media person and my new firm is a millennial. There's all sorts of stuff I don't know about that. So I think that there's a great synergy in having a few white hairs and then combining it with someone who has all their hair.
Absolutely. So what's the biggest mistake you've made in your career?
Okay, the biggest mistake I made many times is being a poor judge of character. I have hired people to work with me who I expected would be self-starters. I'm a self-starter. I expect if you come to work for me, you've got a house payment, you're going to work your butt off to get the money to make that house payment. And I've given people, my wife says, attributes they don't possess. So that's something I could have used some help with over the years.
So as a follow-up question, how have you since adjusted your business or made personal adjustments because of that?
Well, I guess in all honesty, I've pared down the number of people who work with me to remove myself from situations where the people I was working with didn't have the attributes that I thought they did. And over time, it was obvious. And so we split. Okay, nothing wrong with being alone. I'm not totally alone. We have six. Our new firm has six people working for us right now, and they all have special skills. 4 of them came from the old firm, so I know how they work. But I don't think you can work in a vacuum. I read a book. This one last thing. I read a book called Free Agent Nation many years ago, and it was all about corporate downsizing. And the message of the book was, for many, many years, my parents, had loyalty in the corporations from the top down.
Mhm.
That all changed. That all changed in the 80s. The only loyalty now in a corporation is the team, the work group. It's a horizontal loyalty. So when you're out there doing business and you're kind of working on your own, it's good to find people to do projects together, and you develop a loyalty and get your project done. It's tough to work totally on your own. And as we're doing this, we're all stay at home. We're all in the COVID thing. It's difficult. We've gone to morning meetings every single morning, a Zoom meeting like this with my whole team. We need it, as opposed to going to the office. So
That really strikes a chord with me. But so question number 4, and this ties back a lot into what you said for number 2, is what's been your favorite way to incorporate technology and social media into your business?
Finding other people that know how to do it.
Good answer.
Yep.
And then last question is, what book has most influenced you along your journey?
The book is called The Shack, SHACK.
Mm-hmm.
And it's a book that has a message. And in my life, the message appeals to me and is pertinent to me. And that book is a book that I've purchased many, many, many copies and given those copies to people who I believe need the same message. Although there is another book, a guy and I wrote a book about my dad. My dad was a Marine Corps fighter pilot and won the Navy Cross. And we decided to write a book about him. And it's on Amazon right now, and it's an amazing story. My daughters are not interested in war history. I'm an only child, so this guy came to me, who was about my age, who had met my dad years ago, and said, "Do you have any information? I'd like to write a book." So we wrote a book about my dad. Pretty cool.
What's that book called?
Oh, an American Hero, and it's Eugene Trowbridge is the name of the book, An American Hero. My dad was directing the band in San Diego on the day that they bombed Pearl Harbor. And within 90 or 120 days, he was the first pilot to land on Guadalcanal as a Marine fighter pilot. And the rest is history.
Wow.
Yeah.
Patriot.
Well, Gene, thank you so much for coming on today's episode of the Millennials and Multifamily Podcast. If any of our listeners needed to reach out and get in touch with you, what would be the best method for them to do that?
Well, to get directly to me, you can call me, 949-855-8399. My email is gene@trowbridgelawgroup.com.
And guys, if you are interested in this, please pick up Gene's book. It is awesome. It's a whole
That's a pretty good book. That hasn't been the most important book in my life.
But it's a good one.
It's good. It's on Amazon. It's on Kindle. And the next person who buys one will let me retire. There you go. I just need one more sale.
That's it. Just one more.
Just one more.
Going on
Thanks,
Amazon
guys.
right now.
Thank you very much, guys. I'm looking at you now. I appreciate it. Thanks.
Thank you.
Thank you.
Thank you for listening to the Millennials in Multifamily Podcast, brought to you by Kronos Investment Partners. If you enjoyed the show, please leave us a rating and a written review at iTunes so that we can connect with more people. Finally, head on over to crownosinvestmentpartners.com and sign up for our newsletter so you can stay updated on everything we're doing. If you're interested in partnering with us as we find new opportunities, you can also schedule a phone call with us under the Contact Us tab at crownosinvestmentpartners.com.